and good day to everyone. My name is Nur Hidayah Abramolo and my metric number is 281021, and I'll start the presentation by explaining what is subjects of international law and legal personality. The term subjects of international law are capable of possessing, exercising, and enforcing varied degrees of rights and duties under international law. They may also contribute to the creation of international law. Subjects of international law can be broadly categorized as states and non-states. States at a conceptual level have equal rights and duties under international law by virtue of the principle of sovereign equality. Apart from the states, organizations may have these capacities and immunities if certain conditions are satisfied. Now, I will explain the overview of this case. So, this case was initiated by the incidents of agents and ambassadors of the United Nations that had continually attacked and hurt during the performance of their duty as representative of the organizations. However, at that time, the United Nations had no power to act over the different states, as there was no precedent case that constitute on the legal personality of the international organization. The incidents had culminated on September 17, 1948, with the assassination of the United Nations mediator in Palestine, Count Fort Bernadotte, and a United Nations observer from France, Colonel Serrault. Both of them were assassinated by paramilitary Zionist group in Jerusalem. As a consequence of these incidents, the United Nations asked advisory opinion to the International Courts of Justice whether the United Nations had the capacity to bring an international claim against the state that are responsible with a view to obtaining reparation for damage caused to the organization and to the victim. The Secretary General, in submitting these questions, stated that he had no doubt that the UN, which has capacity to enter into international agreements with states, possesses the legal capacity to present a claim under international law against a state, whether it's a member or a non-member of the United Nations. So now I will explain the submission of the statements to the ICJ. Okay, in a letter of December 4th, 1948, filed in the registry on December 7th, the Secretary General of the United Nations forwarded to the court a certified true copy of the resolution of the General Assembly. The written statements were received from the following states, which were India, China, United States of America, United Kingdom of Great Britain and Northern Ireland, and also France. These statements were communicated to all states that entitled to appear before the court and to the Secretary General of the United Nations. Furthermore, the Secretary General of the United Nations and the government of the French Republic, the government of the United Kingdom and the government of Kingdom of Belgium informed the court that they had designated representatives to present oral statements in the course of public sittings that held on 7th, 8th and 9th of March 1949. I think that's all from me. Thank you.
Hello everyone, now for this section of the video, I'll be explaining about the questions brought up within the case, the court decision on this matter, and the principles derived from the case relating to the topic. Now there are two main questions that were brought up within the case, with the first question having two subparts. And these are whether the United Nations as an organization has the capacity to bring an international claim against the responsible in order to obtain the reparation due to the damage caused not only to them, but also to the agent affected in this case. While the second question on how the actions by the UN is to be reconciled with such rights as may be possessed by the states of which the victim is a national, if the answer to question 1B is affirmative. Now keep in mind, both questions ultimately examines the identity of the UN, whether they are of international personnel. And to answer this question, according to the court, was to address whether the UN possessed an international personality. And the answer to this was yes. Indeed, they do. And why is that? It is because a personality does not necessarily mean a state, but rather it depends on the purpose and function specified. With that said, it is also to be noted that although the UN is an international personality, this does not mean that the organization possesses the same rights as those of a state. A follow-up to this question was, what about the damage caused to Mr. Bernadotte, their agent? Well, to answer or to say the solution to whether the UN has the capacity to claim damage to its agent was not explicit in the UN Charter. However, the concept of implied power were mentioned to this matter. The court ruled that the UN possessed powers not only ruled out by the UN, but also possessed bestowed powers by necessary implications, which in this case was to protect their agent and to safeguard their institutional independence. And for this to be granted, the UN needed to obtain the capacity of bringing a claim to the damage caused not only to their organization, but also to their agents. So, conclusively, the answer to this question was yes. The UN does have the capacity to bring a claim for the damage not only suffered by the organization, but to their agents as well. Now, the next question was how is the action by the United Nations to be reconciled with such rights as may be possessed by the state of which the victim is a national? And the answer to this, as mentioned by the court, was that the risk of competition between the organization and the national state can be reduced or simply eliminated either by a general convention or by agreements entered into each particular case. And since the claim brought by the organization is not based upon the nationality of the victim, but rather upon his status as an agent of the organization, it does not matter whether or not the state to which the claim is addressed regards him as its own national. For closure now, I'll be restating the principles derived from the case, which relates to the topic of subjects, international law, and personality. Now, point one is that UN is indeed considered a legal personality, as a legal personality depends on the capacity to enforce one's own rights and to compel other subjects to perform their duties under international law. The ICJ also claimed that the international legal personality of UN was derived from the UN Charter and the organization's given mandate and functions, for without it, the UN could not perform those tasks it was required to by the UN Charter. And that is all for this case. I hope the explanation was clear-cut, and thank you for your attention.
Hello Doctor, I'm Chachashi and my matrix number is 278004, and now I would like to talk about overview of the legality of the use by a state of nuclear weapon in armed conflict. In 27 August 1993, the Director General of the World Health Organization requests an advisory opinion from the International Court of Justice. So the question is asked about, would the use of nuclear weapon by a state in war or other armed conflict be a breach of its commitment under international law, including the WHO Constitution, given the health and environment effects? When a specialized agency submits a request for an advisory opinion to the court considers three elements that must be met in order to establish the court's jurisdiction. The first one is the agency requesting the opinion must be lawfully authorized by the Charter to seek the court's opinion. And then the second one is the requested opinion must be on a legal subject. And then the last one is that arises between the scope of the asking agency's activity. Now, let's talk about the issue of the case. The issue of the case study is whether the threat or use of nuclear weapon is permissible under international law in certain situations. In this case study, the World Health Organization issued a question to the court, that is, in view of the health and environmental effects, would the use of nuclear weapon by a state in war or other armed conflict be a breach of its obligation under international law, including the WHO Constitution?
Hello doctor and fellow friends, I am Chang Yong Wei and my matrix number is 277920. Next, I'm going to present about the phase of the case. So what is the phase of the case? The World Health Organization has approached the International Court of Justice for an advisory opinion on whether countries should be allowed to apply nuclear weapons in war or armed disputes in conformity with international law.
Good day doctor and everyone, my name is Chong Yen Yin and my matrix number is 277789. Now I'm going to present about court decision toward the case. On 8 July 1996, the court determined that it was unable to provide the World Health Organization with the advisory opinion requested on the legality of the use by a state of nuclear weapons in armed conflict. This is because the court notes that the WHO function are listed in 22 subparagraph A to B of its Article 2 Constitution. None of these subparagraphs expressly related to the legality of any health risk behavior, and none of the WHO functions are contingent on the legality of the situation in which it must intervene. Additionally, Article 2's initial language states that the organization performs its task in order to achieve its objective. The organization's aim is specified in Article 1 as the attainment by all people of the highest possible level of health. Also referring to the preamble to the Constitution, the court determined that while the WHO is authorized by its constitution to deal with the health effects of nuclear weapons use, or any other hazardous activities, and to take preventive measures aimed at protecting the health of population in the event that such weapons are used or such activities are engaged in. The question presented to the court in the current case related not to the effect of nuclear weapon use on health, but to the legality of the use of nuclear weapons. It goes on to say that the question before the court in this instance is not the health impact of nuclear weapons, but their legality in light of their health and environmental implication. The court further notes that the WHO ability to cope with the repercussion is independent of the act that regenerated them. As a result, the court does not believe that the provision of Article 2 of the WHO Constitution confer on the organization the competence to address the legality of the use of nuclear weapons, and thus the competence to ask the court about that. Additionally, the court noted that international organizations are bestowed with powers by the state that form them, and their borders are decided by the shared interests entrusted to them for promotion. Furthermore, the WHO was part of a system based on the United Nations Charter that aimed to coordinate international collaboration by bringing the United Nations, endowed with extensive powers, together with autonomous and complementary sectoral organizations. As a result, the court ruled that the WHO obligation must be limited to public health and cannot overlap with other United Nations agencies. Force, weapon, regulation, and disarmament were clearly concerned for the United Nations, not the specialized agency. That's all from me. Thank you.
Next, I will explain about the principle derived from the case which related to the subject of international law and legal personality. The legitimacy or unlawful application of nuclear bombs rarely decides that particularly actions, whether related to healthcare, wellness, or anything else that may be critical to avoid or treat any of their consequence, according to the International Court of Justice. The court also recognized that international organizations may execute authorities not explicitly provided for in the aforementioned instruments which regulate their actions. Nevertheless, the court contends that the competence to decide upon the legitimacy of nuclear bombs use cannot be interpreted as a necessary inference of the World Health Organization, given the aim granted by the states of member, or else it would be comparable to disobeying the rules whereby the international bodies conduct limited scope of work. Despite international bodies being one of the subject of international law, the above judgment by the court evidently indicates that international organizations do not have the same legal personality, rights, or obligation as a state. The court justified that the Charter of the United Nations structure illustrates that the United Nations was given broad powers, whereas specialized bodies such as the World Health Organizations were allocated sectorial authorities. The World Health Organization's tasks must be limited to the healthcare field, and it cannot intervene upon the function of United Nations structure, particularly issues regarding the application of force and weapon supervision fall under the jurisdiction of the United Nations and not under the international bodies. Referring to the principle of legal personality, any person or institutions will be entitled to what rights depend upon the scope and character of the law. Every subject of international law must follow the rules to perform duties under their area. This is their responsibility since they possess the subject of international law. Hence, it was determined that the World Health Organization does not have the authority to obtain a will upon the clarifications of its constitutions on matters beyond its scope.